Hi, I'm Rui-Jie, and in this presentation, I'll be talking about the work I did with Alice Xiang on tensions between legal and technical considerations in the application of the 2008 Illinois Biometric Information Privacy Act, or Illinois BIPA for short, to facial processing technologies. I think when we think about the regulation of facial recognition technologies in the FACT community, we think to the seminal work of Joy Buolamwini and Timnit Gebru in banning its use by law enforcement. But facial processing technologies as a whole continue to be developed in a wide variety of contexts by a wide variety of actors in the United States, where they are primarily regulated by consumer information privacy laws. In recent years, Illinois BIPA has shown itself to be among the most impactful US laws that govern facial processing technologies in this range of contexts. It is the only biometric privacy law in the United States allowing private individuals to directly sue regulated entities for the non-consensual processing of biometric information, and it governs biometric data generally. As a result, the policy has generated cases against a tremendous breadth of different types of facial processing technologies within different contexts, and has even created incentives for companies to preemptively disable facial processing in Illinois. In this presentation, I'll talk about what we found after actually going through applications of BIPA and court opinions involving facial processing technologies. I would be remiss to claim that I could take a few cases and generalize into how facial processing technologies are and will be regulated by BIPA, because many of the cases we analyzed are still ongoing and some of them have since reached settlements from the time we wrote this paper. But what I can say is that what we have found so far points to potential disconnects between technical and legal considerations. I'll first discuss legal standing determinations based on concrete and particularized harms. Legal standing is important because it determines whether a plaintiff has a right to bring suit, whether they might be eligible to recover damages as a result of alleged violations of a particular policy. Then I identify points of tensions between legal and technical communities, areas where the technical operationalization of BIPA may create unintended and undesirable incentives for facial processing technology development, in addition to areas where BIPA litigation has brought to light the limitations of solely technical methods in achieving legal privacy values. Finally, I present technology and policy implications for facial processing technologies that arise from this analysis and these disconnects. Plaintiffs in privacy lawsuits have generally focused on satisfying the federal standing requirement that the alleged violation of a policy has led to an injury in fact, or that the violation of a policy has brought a concrete and particularized harm, where particularized is taken to mean a harm that is specific to an individual. BIPA court opinions have been unique in that several violations of the policy have been recognized as an injury in itself, but this hasn't always been the norm for the policy. Courts have also assessed violations of different provisions of BIPA in a variety of different ways and have also dismissed several alleged violations in cases involving facial processing technologies. So BIPA seeks to protect biometric data in financial transactions and address public hesitancy surrounding biometric information use. The policy intends to prevent privacy harms that arise from the compromising of biometric data, such as identity theft and the theft of financial and other personal information. This legislative intent has also been reflected in several court cases. But we noted lack of discrimination, privacy harm considerations that come specifically with facial processing technologies. The privacy intrusions in cases involving searchable face databases from mugshots and involving the use of diverse training data were taken to be concrete, but courts did not take the next step in acknowledging the additional privacy harms for the increased findability of marginalized individuals that came from the data being mugshots, or the increased targeting of diverse individuals in the procurement and curation of diverse training data. The focus of court opinions on economic and autonomy harms is unsurprising given BIPA's legislative intent and the breadth of technology that it governs, but it has meant correspondingly little consideration for the discrimination harms that facial processing technology development and deployment in particular have imparted and have the potential to impart. The most interesting implications for determinations of particularized harms come from alleged violations of BIPA's profit provision. Courts have tended to determine whether the plaintiffs allege a sufficiently particularized violation of BIPA's profit provision by asking whether the plaintiff's biometric data was disseminated in the use of a facial processing technology, not by asking about the plaintiff's biometric data's contribution to the functionality of facial processing technology, such as through training data. This means that thus far, alleged violations of the profit provision have been upheld as sufficiently particularized for cases courts have perceived to have involved searchable face databases or face matching. But it is worth noting that there are cases where plaintiffs can still allege a sufficiently particularized harm. But when considering just the sort of technologies involved, this has been how courts have approached this question. At the same time, the capabilities of most corporate facial processing technologies would not be possible at all if not for the biometric training data of thousands, if not millions of individuals, with it being difficult to determine how exactly an individual's biometric data influences facial processing technologies more broadly. Considering biometric data's contribution to profit in the development of facial processing technologies rather than just in its dissemination might increase corporate responsibility around how training data is sourced and provide meaningful protections against the privacy intrusions that the subjects of that data might have experienced through their data's potentially covert collection. Now I'll get to the points of disconnects that we've seen from BIPA court opinions. First, while the technical community has emphasized on-device processing as a privacy-preserving mechanism, even to the point of absolving on-device data of privacy protections that would otherwise be afforded to it if it was processed on company servers, the legal community in BIPA litigation emphasizes control over that data, even if that data processing happens on device. For example, in Apple's case involving face grouping on the Photos application, the court noted plaintiffs' lack of data control. They couldn't turn off the collection of their biometric data, even if all of that processing happened on device. There wasn't a way for them to turn off face grouping. The court determined that because of this lack of control, Apple still possessed plaintiffs' biometric data in a way that implicated BIPA protections. BIPA litigation has also considered battery consumption a legally cognizable harm in a TikTok case, suggesting the importance of cost considerations for users' devices and data collection, even and perhaps especially when data collection and processing occur on device. Certainly, the prioritization of battery consumption as a privacy harm above all else would disincentivize the on-device processing of data, even when it can be privacy preserving. For example, in a case where data is consensually collected but processed on device rather than on servers. But these points serve to underscore that purely technical approaches to privacy and data processing are approaches from just one axis, that other axes of consideration should include user control over data processing and perhaps even transparency over energy costs of contributing user data to ML models. Secondly, BIPA and BIPA litigation have also placed a strong focus on consent, not just for companies that have existing relationships with subjects of biometric information, such as social media platforms that allow for users to share image and video data, but also for companies that acquire biometric data in some other way, such as in the acquisition of training data sets. On the other hand, in the development of facial processing technologies, there is a division in the prioritization of privacy as consent among other values, such as fairness. This tension has played out in a string of lawsuits involving IBM's diversity in faces dataset, in which courts have so far upheld that written consent is required for the subjects of biometric information, even when images are public and the companies do not have a relationship with the data subjects. Existing legal mechanisms such as licensing and copyright have attempted to regulate training data, but there's also been research indicating the ineffectiveness of each. At the same time, because it is not trivial to determine whether the subject of biometric data is an Illinois resident to meet compliance with BIPA in obtaining consent, this lack of clarity actually has a potential to strengthen company incentives in obtaining consent broadly and in changing the perhaps non-consensual culture of training data procurement in the computer vision community, incentivizing companies to pursue other avenues such as the generation of synthetic data. Thirdly, BIPA litigation has surfaced several points in the realm of subject identifiability in facial processing technologies. Since BIPA broadly protects scans of face geometry, the identifiability of a particular technology that utilizes these scans, as well as the scans themselves, has not been considered, as long as scans of face geometry are implicated. Meaning, face templates to unlock phones and facial landmarks and face filters, for example, have so far been treated similarly in courts. This might run counter to both BIPA itself, which considers these scans biometric identifiers and emphasizes the potential for identity theft, as well as privacy and security values in the technical community, which might emphasize the potential for identification. Another consideration in the realm of identifiability is that while the technical community has made strides in face obfuscation techniques, BIPA also excludes photographs, including facial photographs, from its protections. There are privacy intrusions specific to images, however, as part of the facial processing technology development. For example, images that are removed from training data sets in which they were non-consensually collected can become even more widely distributed as they are included in copies of data sets made by other researchers. perhaps in recognition of the distinct privacy intrusions that come with the distribution of identifying facial images. Other policies, such as the California Consumer Privacy Act and the EU GDPR, include facial images as part of their definitions of biometric data. The exclusion of facial photographs may also present conflicting incentives in the de-identification processes. For example, in large-scale face obfuscation, facial landmarks might be collected to determine the location of faces to blur them. This is not about identifying the subjects, but about obfuscating their faces. But since BIPA only cares that data is collected and considers facial landmarks biometric identifiers, it is unclear what the policy might create incentives for in such a case. Finally, while the context and purpose of use of a technology is increasingly important to the technical community and how people perceive the material harms of facial processing technologies, the purpose of use does not change the degree of protection that BIPA provides. This is apparent in both the policy and in BIPA litigation. For example, TikTok's collection and use of facial landmarks from its users for face filters, stickers, and demographic classification without obtaining requisite consent landed the company in a $92 million settlement. In this situation, the major privacy intrusion may not necessarily be in the possession of the data itself or the application of that data to impose face filters and stickers on users, but in the misuse of facial landmarks to perform intrusive operations, such as demographic classification for advertisement targeting. However, under the policy, these use cases are not differentiated because it's the underlying data itself that gives rise to BIPA protections, not necessarily the applications. Finally, the technology and policy implications that arise from this analysis and these disconnects are that policy should recognize the importance of protections for subjects of both facial images and biometric data, and perhaps an intersection of these protections. This might be through different treatment of biometric information that's been encrypted or facial images that have been obfuscated. Meanwhile, it is important for facial processing technology developers to keep privacy values beyond purely technical notions of anonymization in mind, such as user control and consumption of device resources. Secondly, identifiability certainly should not be recognized as the only legally cognizable harm. Inferring emotional states or demographic information to target an individual with data that isn't used to identify or isn't necessarily identifying can still be extremely intrusive. But where identifiability is implicated as a harm, the feasibility of identification from a piece of technology or biometric data should be meaningfully considered. Thirdly, the settings in which facial processing technologies are developed give useful guidance over perceived privacy harms and should influence both the design and regulation of a technology and its data. And finally, policies that govern facial processing technologies should recognize the market for facial data and aim to provide guardrails in the procurement of it. This comes with the recognition of privacy harms that could come with the procurement and utilization of face data and the development of facial processing technologies. Thank you.